Are you facing false allegations by a narcissist in your custody battle? There's a critical mistake that even experienced parents make when responding to a narcissist, and it's what the narcissist counts on to build their case against you. Get this wrong, and you'll spend more time defending allegations than building your credibility and your case. My name is Jeff Hughes, and I'm the lead attorney for Sterling Lawyers. We are a large, exclusively family law firm in Wisconsin. We see hundreds of cases and judges every single month, and that gives our clients an unfair advantage. And in this video, I will lay out the 3 strategies to fight back against a narcissist's lies and use their attacks to prove your case. I will also describe the 3 common traps that narcissists try to set and how you can avoid them. Now, to start with, recognize that you are in a 2-front battle. You and the narcissist are co-parenting. Whether you like it or not, you have to communicate and discuss things about your children that you have in common. And what happens in these interactions are used as evidence, as fodder, as a means to attack you later on in front of a court official or while you're in court. So understanding that the battle takes place in these interactions is important for you to prepare, because what happens here bleeds over and sets the stage for what happens when you're in the court process. Now let's talk about what you are up against when facing a narcissist in a custody battle. From experience, what I have seen with narcissists, they very often can have little or no empathy. They cannot understand that there is another perspective. They can't put themselves in someone else's shoes and see and feel what happened from their perspective. They only are seeing things from their one-sided, jaded, very self-centered, very self-obsessed and focused point of view. They have no empathy. A lot of times, narcissists have grandiose versions of reality, meaning you and the narcissist can witness the same exact event and minutes later describe it dramatically different. How can that happen? It's because they just have these weird perspectives and grandiose points of view. A lot of narcissists have an intense, overbearing, and desperate need for attention. They become drama queens and drama kings. Everything turns into some drama-filled experience. A lot of times narcissists can have little to no boundaries, meaning everything in life is for them to take and be a part of. They don't understand that there are boundaries to relationships. They can be absolute masters of exploiting and manipulating, and they always have to feel in control. So I described all of that, stuff that you've probably experienced a lot of, but it is important as I lay out these strategies ahead that you have a clear-eyed perspective on what you are up against. Because what happens between you and the narcissist almost always finds its way into the court process. You need to be prepared when that happens. Let's move to the second part of the battle that you are faced with. And this is critically important, and that is the battle to persuade the court officials and ultimately prevail in your case. Okay, the first tip, I encourage you not to use the word narcissist and instead describe their behaviors. The reason is because this word is commonly used in the courts. It is used as labels, and a lot of times they don't really apply. And so over time, court officials, judges, family court commissioners, guardians, social workers, they've become somewhat immunized to that word. So it's best that you don't use that because you don't know how they are defining it in their head. Instead, focus on behaviors. Now later, I'm going to describe in this video how you deal with each one of those officials as you work through the court process, because each one requires a little different touch and strategy when interacting and communicating with them. Now, let's move to the 3 strategies. So the first strategy is the communication strategy. Understand, with a narcissist, you face a unique challenge. Their goal is to provoke an emotional response from you. Many court orders require communication, so you can't just ignore them. There has to be interaction because you have children involved. You need to make decisions, you need to coordinate logistics and all of those things. You have to manage those communications very skillfully. Here's a common trap that narcissists set. First, they make an outrageous accusation, hoping that you'll respond with some lengthy emotional defense that they can use to prove their case against you, or that you are the one that's unstable. So every single word you write could end up being twisted and used against you in court, or to the guardian ad litem, or the social worker directly. You can never forget in every interaction that you're dealing with a narcissist, and they are master manipulators of perception. And your communications aren't just between the two of you. You are creating a record that they are hoping to use against you. So let's flip the tables on them. Here's how to do this very strategically. There is a 4-part response: brief, informative, firm, and professional. This method will shield you against their manipulation tactics. First, with respect to being brief, your responses should always be minimal. Narcissists want to draw you into long explanations that they can twist around and make you look silly. Second, they need to be informative. Stick to verifiable facts only. What I mean by verifiable is that someone on the outside can also verify those facts. Narcissists really struggle to manipulate concrete evidence. You want to make it hard on them. Your responses should be firm. End with a clear statement. Narcissists hate boundaries, but courts love them. And finally, your response should always be professional. Maintain a professional tone. They are attempting to paint you as hostile. Now, you don't need to be overly friendly. In fact, I don't even think you need to be friendly at all. There's really not a lot to be gained, but you should always be professional whenever you're interacting and responding back. Now, I believe it is always wise, when you can, unless there is an emergency, follow the 48-hour rule before you respond. This is crucial with narcissists because they often create false emergencies to force emotional responses. You know how it's going. You've probably already been through these so many times. These drama-filled emergencies, things that have to be dealt with right now. You know what? That almost always is not the case. So it is always wise, when you can, to wait for a response. I like to wait 48 hours. That gives your emotions time to simmer down, time to draft a response before you send it. So then after a day has gone by, you can go back and reread that response, fine tune it, make sure it's professional, make sure it's firm, make sure it's informative, make sure it's brief, then send it. Now, for illustration purposes, let's look at a very typical narcissist type accusation to you. So you receive a message that says, "You're obviously neglecting the kids again. They said they didn't eat dinner until 8 p.m. yesterday. I'm documenting everything for the court. You suck as a parent." You've probably got those before, right? What happens emotionally inside of you? Instantly, I know I would feel like I need to defend against that. They didn't have dinner at 8 p.m. They ate earlier, or we agreed to that, or whatever it is. Slow it down. That is not an emergency. That's just another ridiculous attack. So let's walk through a proper response to that type of allegation. There is no need to rush this. You can relax. You can let it sit there. It can just simmer. And so your response, it needs to be written. The children had dinner at 6 p.m. after their scheduled sports practice, which is noted in our shared calendar. Their eating time follows the plan that we agreed to. That's it. You don't need to respond to any of their salacious comments, especially the "you suck as a parent" one. Let that go. You've got it in writing. You will use that against them, with your response being firm and professional. And you can notice how this response doesn't defend against the accusations of neglect. It provides verifiable facts: time, activity, agreed plan, and it maintains professionalism and references official documentation. Now, here's another thing I encourage clients to do. Try the best you can. This is hard. I get that this is an emotional game, but as much as you can, when it comes to responding to the narcissist, think of it detached. Try to gamify it and look at each one of these responses as a challenge for you to respond with that 4-part strategy. And you keep doing that over time. 1, the allegations will become less. 2, you are slowly building your case brick by brick. In time, you're going to have enough facts to show they have a pattern of false allegations. When the courts see that, when you can persuade them accordingly, you have won your case. You have won the credibility battle. And the credibility battle in family court is where all of the wins are. Number 2, documentation strategies. When you're dealing with a narcissist, documentation isn't just important. It is your lifeline. So let's create a bulletproof system for how you can document the facts of your case and ultimately prevail over the narcissist. We're going to talk about why you document, how you document, and what is in your documentation. So why do you document in the first place? If it's just your writing, isn't it biased? Isn't it from your point of view? Well, yes, it might well be. But there are 4 really good reasons why you need to document these events. Number 1, it shows a pattern of behavior. Patterns are what counts in family court. If you come in with an allegation and you make one solitary allegation to the court and you describe what happened, that's one. But when you can show repeated events 5, 6, 7, 8, 9, 10 times where something has happened, well, now you have a pattern. That is so much more persuasive than 1 or 2 or 3 solitary explanations on someone's behavior. Number 2, you use documentation to refute these false allegations. When you have the false allegation in writing and you put the response in writing, concise, just the facts that are verifiable, you've won that argument. And when you can do that repeatedly, you can win your case. You do it for a third reason, to refresh your recollection. Now, sometimes, unfortunately, custody battles, well, can last months, quarters, even years in the state of Wisconsin. Over time, the facts can start to sort of merge together. They can be jumbled as you try to retrieve them from months or quarters ago. But if you've got a description of that event, you can reference back, you can refresh your recollection, and that is so valuable if you're testifying in court. That is so valuable when you're talking to the guardian ad litem and you're giving the guardian the documentation that you have put together over all this time. So that's the 4th reason why you document. Now let's move to the 3rd part of documentation. That is how you document well. First off, do it on a computer. It is so much easier to edit, to reorganize, and to use later. Don't just write it in a notepad. If you write it by hand in a notepad, transfer those notes soon, transfer them to a computer. And if you don't have a laptop or a tablet, you can do it on your phone. It's just harder to put all that there. So put it in electronic form so it can be edited and adjusted later and reorganized in a way so that the court official can use it well. Now, as much as possible, make your descriptions simple and concise so someone who wasn't there, who doesn't know you, who doesn't know the other party, can look at that and can understand what's going on. Oftentimes with this documentation, less can be more. Simple and concise, less is more. You're going to have to get into the habit of keeping records of everything, even if it seems minor. In your descriptions, stick to just the facts. Avoid your opinion. That'll make you seem more credible than adding your commentary as to what just happened. Be truthful. Even if you're in the wrong on something, describe where you were wrong. Don't run away from that, because this whole experience in a custody battle is about winning the credibility battle. Ultimately, the judge, the guardian, the social worker, they are going to make a judgment on your credibility. You want to be seen as the more credible, the more believable, the more truthful party in your case. Now, as you're writing, do it chronologically. Keep a chronological order of all of the events. Don't skip around. That's too confusing for someone else to read and understand. Always remember who you are writing to. The judge, the court commissioner, the guardian ad litem, the social worker, and sometimes even your own attorney. Remember who you are writing for. Now, you are not writing that for the narcissist, obviously. You're not writing it for your friends, your family members. You're writing it for just those individuals. They are your audience, so write everything with them in mind. Now let's break it down for each of those court officials. First, starting with the judge. Now, with the judge, it can be somewhat tricky getting all of your documentation in front of a judge because the rules of evidence come into play here. And a lot of times, some judges are very strict on the rules, some of them are not. It all depends on your individual judge. And in family court, the judges can be very lax at times on the rules for evidence they can look at, and sometimes they're very tight on those rules. It really depends on the judge. But it will not hurt for you to get all of that together because you don't know until you get to court sometimes if you haven't had experience with this particular judge before. And at the very least, you can use your documentation to refresh your recollection. Another person you might be in front of is the family court commissioner. Their ability to not follow the evidence rules is even greater than the judges because they can look at documentation at their discretion. It's important to have your documentation ready to present it to the family court commissioner if asked or if the opportunity comes up. Now, another party that's often involved in custody battles is the guardian ad litem. Now, a guardian ad litem is another attorney appointed by the court, and their job is to advocate for the best interests of your child or children. That's different than someone who's advocating for what your child wants. That is not as relevant here. They are to advocate for the best interest as they deem them to be for your children. You can share all of this with the guardian ad litem, and I encourage you to do so. And when you do that, give them your documentation in a very organized, concise, simple fashion because you want them to read it. And if you dump too much on them, that seems overwhelming. They can't get through that. A lot of times they just don't need it, or they'll glance through it. They'll kind of give it a cursory review. You don't want that to happen. You want to make it easy on them so when they go through that, they can get a really good sense for what's going on and find the patterns that you're trying to explain. A lot of times there's a social worker involved. A social worker is appointed by the judge to do what's called a home study or to do a study of something that's going on in the case. They are much like the guardian ad litem in that they are looking for factors that are in the best interest of your child, and they want to promote those or make recommendations based on those factors. Now, they're not advocates. They're just another witness that the judge will call on and rely on heavily when rendering their opinion. So social workers are important. A lot of times also the courts will appoint a therapist or a psychologist to do a psychological evaluation on the parties, and they'll want to see this documentation. So prepare it with them in mind as well. Now let's talk about what. What do you actually document? Put the date, the time, the location, and what happened. And remember, just the facts as honestly and as accurately as you possibly can. If you have photos, if you have videos, put them in there too. Headline those descriptions so you can reference them easy. So when someone's reading it, they can read the headline. If they're interested, they can go deeper and read the story. Get in the habit of saving everything systematically. Texts, emails, even social media posts. Save them all. Organize them so someone can flip through all of your documentation and see what happened and get an overall feel for what you're trying to explain. Sometimes judges will order parties to communicate through an app. A really popular one is called Our Family Wizard. That keeps a track of everything and date stamps everything, so that's pretty convenient and you can erase stuff out of that, but sometimes you don't have that. So you text or you email. Let me talk about the use of video cameras. I would encourage you to invest in them if you can and try to use as many angles as you can if you're setting it up at your house or in your car. They need to be out in the open. If you want to use the video later as evidence, it can't be hidden. Everybody involved needs to know that the video camera is there. A lot of times people forget that cameras exist. That's when they let their guard down and they do things that may help you. Wisconsin is a one-party consent state, which means that only one party needs to know they're being recorded. You can do that in Wisconsin, but that doesn't necessarily mean you will get that video in as evidence. Both parties need to know that the video camera is rolling or that it exists before you can introduce that as evidence. But sometimes you can take those videos and share those with the guardian ad litem, with the social worker, and that could be very helpful for your case. If you do that, let the guardian ad litem know that the other party knew the video was being taken or that they knew that they existed. Because sometimes some guardians just don't like it. One party records another without their knowledge or consent. They look upon that as suspicion, and that could cast doubt on your credibility. So the third strategy are the legal strategies. And it's important that you know the difference between legal and non-legal issues so you know what to respond to. If you get caught up in responding to a bunch of non-legal issues or non-legal allegations, they're going to distract you and sap the energy out of your case, and it may even affect your credibility along the way. Legal issues are issues that affect parenting or the best interest of your child, your fitness as a parent, the narcissist's fitness as a parent. Those are all important in your custody and placement battle in Wisconsin. Those have to deal with the legal issues all around the children there. So when it comes to non-legal issues, your personal pain, your personal suffering is almost always not relevant in a custody battle. That may hurt. It definitely is real. It definitely strikes a chord with you, but it most often is not important in your case. So don't get distracted dealing with those when it comes to the court battle revolving around custody and placement. Also, as a part of your legal strategies, understand who and how you have to persuade the court officials involved in your case. The guardian ad litem and the social worker should be a point of emphasis on your persuasive efforts, because they are going to make recommendations or they are going to advocate something to the judge, and you want them to advocate for the truth in your particular case and that you are the most qualified parent in this custody and placement battle. The family court commissioner, remember, they are not a judge. They're only temporary. The judge is the one who has ultimate say in your case. Your exposure to the judge will probably be very limited relative to the guardian ad litem or the social workers involved. When you get to the judge, your time is limited with the judge because the judge's calendars are almost always full, almost always busy. And so your efforts should be limited to the most persuasive case you can possibly make. Another legal strategy is to use contempt motions and motions to modify or motions to enforce. Only use these when you have very solid evidence and believe that evidence is highly persuasive to a family court commissioner or a judge. The reason is you don't want to use these and go in the court and be beaten, because that damages your credibility. So be careful about using these. Only use these when you know you have a very strong case. Also, if police are ever involved in any of your interactions with your ex, make sure you get copies of that police report as quickly as possible. Ask the officer to draft up a report. Don't wait until right before court to do that. Get it and have it in hand right away. Also, when it comes to court orders, make sure you always follow them to the letter of the law. Judges and court commissioners do not like it when a party violates, ignores, or does not follow a court order. So maintain the high ground. You be the one to always follow the court order. Now let's conclude with the common traps when dealing with a narcissist. Now, narcissists are experts at triggering emotional responses. So here are the traps to avoid. Number one, the emotional response trap. Don't respond emotionally to their personal attacks. That's what they want you to do. You are playing directly into their hands when you do that. Remember to stick with business-like communication. Follow the 48-hour rule. Another trap is the jade trap. Justify, argue, defend, explain. J-A-D-E. Don't justify your parenting decisions. There is no need to do that to the narcissist. State the facts and then move on. You do not need to explain the facts. Just give them to the narcissist. End of story, period. Keep your responses focused on the children's needs. Remember who your audience is now. Everything that you say and do should be documented. Ultimately, you may find that that is in court. When that happens, you want to be proud of your communication, not worried about how it might affect you in court. Another trap that's so common is the public image trap. Please do not engage in social media battles. If they are engaging in a campaign of social media scorched earth on you, stay disciplined. Document all those attacks and later use them against your ex. Okay, in closing, remember this. A narcissist's false allegations reveal their fears and tactics, not your character. Stay focused on documentation, not on defending yourself. Your calm, consistent responses through record keeping will speak louder than their accusations. And most importantly, remember to protect your peace of mind. It's your strongest asset for your children's well-being. So if you're dealing with a difficult ex, I recommend watching our video right here, Tools for Co-Parenting with a Toxic Ex. This is where we cover more strategies for maintaining boundaries and protecting your peace. See you in the next video.